May it please the court. Good afternoon. When Congress enacted the Mining Act of 1872, it explicitly envisioned a role for state and local laws. The purpose was to encourage mining that complied with federal, state, and local laws. And so for more than 100 years, California law has affected mining and its profitability. We banned hydraulic mining. We tax mining claims. We have a whole host of laws that affect mining's profitability.
Counsel, your theory of the statutes here and their purpose presumably nonetheless still implies some acknowledgement that there are limits on what the state can do. And if so, what are those limits?
The limit is that the state cannot enact a law so that it's impossible to comply with federal law and state law.
That it's impossible to comply with federal law and state law.
So you're suggesting that there's no purposes and objectives preemption claim that is possible with respect to the Mining Act of 1872?
No, I don't mean to go that far, but the purposes include, the full purposes of the statute are to not only encourage mining, but also to allow states to regulate mining.
Well, if you're encouraging mining, but the state precludes the only viable method of mining, how does that work out in your theory? Well, that's the postulate of the case here, that although he had the right to mine, the environmental regulations precluded his using the suction method, and he argues that's the only method that was feasible.
He argued that it was the only economically feasible
All right.
to mine. It's certainly possible for Mr. Reinhart to mine his claim. He can mine outside of the river. He can also mine using non-motorized methods. They might not be as efficient. He might not make as much of a profit, but he can certainly mine.
So your position is he has a right to mine. He doesn't have a right to mine in a given way.
Correct. That's correct.
Does it matter at all how practicable or not the available methods of mining remain? So if his only available method is to take a sort of a garden shovel and dig in the dirt, that's the only thing that state law would permit him to do, is that a problem from a federal preemption standpoint?
I don't think that flows from the language in the statute or from what the federal agencies have talked about here. So I understand there may be some unease with that proposition, but the statute here doesn't make distinctions other than whether the state law is inconsistent with federal law.
And when you say the statute here, you mean the Mining Act, but what's your sense of the relevance of the Multiple Use Act?
You're referring to the statutes enacted in 1955.
Correct.
We don't believe that Section 612B, which is what Mr. Reinhart has focused on, is relevant at all.
Why not?
Because it only refers to limits on the United States, its permittees, and its licensees. There's no reference to states at all. And in fact, 612 is followed by 613, which 613 lays out the process for resolving conflicts between miners and the United States. And it talks about federal agency and has no reference at all to anyone but the federal government.
So I guess I'm trying to understand why you would draw the line in the place that you're suggesting the line should be drawn. So it sounds like you think that it would be a problem from a federal preemption standpoint for a state to ban mining altogether within a claim under the Mining Act of 1872, but it's okay for a state to effectively ban any form of mining that might actually yield a product. I mean, is that an accurate characterization of your position? And if so, how do you draw that line looking at the text and the purposes of the Mining Act?
Well, I think there's a couple reasons to draw the line there. 3 reasons, at least, that I can think of. So the statute speaks to laws that are inconsistent with the laws of the United States. Okay? And inconsistency to the common person is the same as a conflict. That's a bright line to draw. If we draw the line somewhere else, then we're going against the presumption against preemption, which asks us to interpret preemption in the narrowest way possible. We're also not giving enough credence to the federal agencies who have come to that conclusion. And perhaps most importantly, if we draw the line at some place that's like economic practicability, we run into all sorts of problems. The price of gold has fluctuated wildly over the course of this litigation and in the past 10 years. Different miners have different abilities. Different places have different amounts of gold. And if we have a standard that's as subjective as economic practicability, then we have a situation where preemption depends on whether it's 2003 or 2010, whether I'm mining the claim or an experienced miner is mining the claim. And that is not something that Congress intended, certainly. And so I think all those things point to us wanting to have a bright line rule here.
Do those arguments suggest that the Lawrence County case was wrongly decided?
I think the Lawrence County case, I personally think it was wrongly decided, but I also think it's very distinguishable because it was explicitly a local zoning law. So it was a county, and a small portion of that county was prohibited from any mining. Here, we have a statewide law that applies throughout the state. It's in no way a local zoning ordinance.
And why does it matter for purposes of the analysis whether a local ordinance or a statewide law, if the question at the end of the day concerns the quality of and degree of interference with mining under federal law?
Well, because Granite Rock has a great amount of dicta talking about it's important to make a distinction between those two. That's why it matters.
And what is the reasoning underlying the distinction?
Well, I think it's important to make that distinction because we're dealing here with federal land, right? So it's appropriate for federal agencies to make decisions about whether land is used for housing or commercial or mining or something like that. But in contrast, when you have an environmental regulation like this is, that focuses on the significant environmental effects, then you're back in the wheelhouse of the states. The core police power of the state is to protect fish and wildlife, water quality, its citizens, and so environmental regulations fall within that scope, and the court should be more deferential of that.
Is your position, counsel, that there really is no obstacle preemption of the Mining Act?
No. But I think obstacle preemption depends on the purposes of the statute.
If you say that the purpose of the Mining Act is to sort out title and possession to lands that are available for mining, subject to compliance with state, local, and territorial law, isn't that kind of a closed loop there? I mean, you can never really have any obstacle preemption because no matter what the state local law is, it'll always be caught by that purpose. Other than the express carve-out for laws that are in conflict with laws of the United States governing possessory title, right? But the whole panoply of environmental regulation or any other kind of regulation seems not preempted, even if it deprives the possessor or owner of all economic value related to mining of that land.
I think that's what Congress intended.
And what's your best evidence for that?
the
Congress having that particular purpose in mind?
That from the language of the statute, and from, remember, the history of the Mining Act. The Mining Act was enacted after California Gold Rush. And California's gold rush was the Wild West, right? And local groups in the state set up their own rules and regulations. And Congress meant in 1866 and then in 1872 to leave those in place. And I don't think I need more evidence than that. I mean, the language of the statute is, this court has held in Viva, the language of the statute is the best evidence of Congress's intent. Getting back to your question, it may be that the sliver of obstacle preemption over and above conflict preemption is very narrow. It may be true, but that's due to the language that Congress enacted. And there are cases that speak to when Congress has enacted specific language, do we go past that to imply preemption? And sometimes we do, and sometimes we don't.
Well, I think it's fine. I mean, as a possible position, I'm just wondering what your position is.
Yes.
I mean, is there any obstacle preemption available here? Given, I mean, I'm just wondering what the breadth of your theory is.
Oh, I think in this case, there is no obstacle preemption.
I know, but where does that take us? I mean, is there ever any possible obstacle preemption?
It's hard to think of a situation, but I think there could be. I think there could be.
How could it ever come up?
Well, I mean, for example, if California passed a statute that said no mining of any kind is allowed in the entire state, that I don't see that happening. We have plenty of statutes that encourage mining here in California, but that might go so far as to, pass that line.
Under an obstacle preemption theory or under a conflict preemption theory?
It would be an obstacle preemption theory, because there's nothing in the Mining Act that requires any miner to mine, right? They can claim a mining claim, they can do maintenance work, they can pay their fees, but they don't have to actually go on site to continue to hold that mining claim.
So why would it be that a state law that bans mining altogether would pose an impermissible obstacle to the achievement of the purposes underlying federal law, but a law that bans most forms of mining, all forms of mining, that would make it worth anybody's while to mine, would not pose the same type of obstacle?
Because when Congress enacted the Mining Act of 1872, it gave miners the opportunity to go on federal land and seek gold, but it didn't guarantee them that. It didn't guarantee they'd find anything. It didn't guarantee that they would find enough to make profit. It encouraged them to do it, but it didn't.
Counsel, as I understand it,
Sorry.
your argument is that the federal law does not, the California law that's coming out of California's concern with the environment, Do you want to elaborate on that, or is that the beginning and the end of your argument?
Well, I think Mr. Reinhart has conceded that California can adopt what he calls reasonable environmental regulation.
And does he concede, I'll hear from him, but that this is reasonable environmental?
No, of course, he characterizes it in a way that's unreasonable, but I think quite reasonable what the legislature did here.
So is what you have to argue against the idea that because banning the sucking method removes any economically feasible or commercially feasible method of mining, that it's preempted? Is that what you have to defend?
No, we didn't ban suction dredge mining.
I'm sorry, I can't hear you.
I'm sorry. We did not ban suction dredge mining. We placed a moratorium on it for a period of time while an environmental review was proceeding.
So what's the difference between banning it and establishing a moratorium? Other than that there's a moratorium could come to an end, but as long as the moratorium is in place, it's banned. Isn't that right?
Right. A moratorium can be characterized as a temporary ban, certainly.
So I'm not sure that assertion is compelling as an answer to Justice Werdegar's question, to say, well, we didn't really ban it, we just established a moratorium. I don't think that gets you there.
Well, it may be that I didn't understand Justice.
May I ask you the question without, I remember reading it, but I want to hear from you. I know the legislature had and gave great consideration before it imposed the ban/moratorium. So and I know that the state acted in a way to regulate protection and public use. What did it find, the state find, were the dangers of suction mining? Why do they need to conduct an environmental study of such a thing?
The reason that this environmental review was done was because suction dredge mining is what it is putting a vacuum in the bottom of a river and sucking the gravel and the rocks and the dirt out. And what that does is it affects the habitat of fish. And specifically what caused this environmental review to happen was that there were threats to endangered salmon in Northern California. And the concern was that was affecting, that suction dredge mining was affecting those endangered fish. So there are those concerns. There are also concerns because suction dredge miners target areas that were mined previously. And California has a history of using mercury to mine. And so there is mercury in the sediment in the rivers that we have where these fish live, but that also flow to San Francisco Bay, that when suction dredge miners do their work, they pull all of that mercury out, and it ends up in sediment in the water column and flows down to where people live.
Which is your argument that this is quintessentially a police power exercised by the state to protect the environment, and that the Mining Act from 1872, enacted after the gold rush, as you said, the Wild Wild West, to encourage mining and settle property expectations, never meant to displace the state's inherent sovereign authority to regulate the environment of its land and waterways for public use.
Yeah, I agree. And there's further evidence after the Mining Act of 1872. California banned the mining method of hydraulic mining, and Congress took notice of that. It knew that it affected all those businesses, and it, instead of affecting that ability to ban hydraulic mining, it set up what was called a debris commission to further regulate hydraulic mining. And so that's further evidence that Congress didn't intend to upset this police power.
You've mentioned the text several times, going back to the prison discussion. And I certainly accept and believe that the text can tell us a great deal about what the legislature is trying to accomplish. But help me zero in on the text that you think is most helpful to your position.
It's the phrase, under regulations prescribed by law.
Got it. So your argument is that piece of the statute is underscoring that what the legislature is trying to accomplish here is to protect a sphere of police power for the state.
Yes, because the word law is normally meant to include federal, state, and local laws. And that's also emphasized by the last phrase, which says, so far as the same are applicable and not inconsistent with the laws of the United States. So laws in comparison to laws of the United States, the difference underscores that that's meant to protect state law.
Do you see Section 21A of Title 30 as being relevant in terms of considering what the operative purposes of the federal statutory scheme are? Should it play a role in our consideration of this issue or not?
Certainly. I mean, the United States filed an amicus brief in this case, and they made the point that this provision, as well as other federal laws, recognize that the environment is part of the balancing, and that mining isn't to be encouraged at all costs, that there are environmental needs, that's the phrase that it uses, that need to be taken into account as well under the Mining Acts. I've lost track of time, but I think my time is
Your
up.
time's expired. You'll have 8 minutes for rebuttal.
Thank you.
Good afternoon, Your Honors. You all issued an opinion in December in the Cazada case, which discussed federal preemption at quite some length, and we didn't have an opportunity to brief it. But one of the things that you said is that the court should not lightly infer an intention to negate the state's exercise of sovereign power. And one of the things that you said, that's based on a respect that sovereigns have for each other. And so what I'm here today to urge you is that respect and comedy are a two-way street. And that what is going on here is that California is totally disrespecting the federal policy. And to get to that point, I want to push very deep into what that policy is. And I want to do a quick run through all the statutes. We've talked about Section 22. He's mischaracterized it. The part about regulations under law referred to mining districts. It was regulations of mining districts, and the so far as not inconsistent is a straightforward adoption of obstacle preemption. There's a large body of authority construing this. There are other sections of the mining law, I think in 35 and so forth and so on, which talk about state law, the state law related to the acquisition of title, miners fighting over claims, all this kind of things. There's a role for state law, but even going back to the turn of the century, it was always the law that whatever the state did, to quote the Butte City case, could not interfere with the liberal spirit of the mining laws. Now, later we come out to sections...
It remains the case, does it not, that the state has not banned mining. The state has said you just can't mine using this technique.
I would agree that it is true that Mr. Reinhart can still use a teaspoon. He can use a gold pan. But this gold is underwater, and you can't breathe underwater without equipment using motors. It places the valuable minerals in his claim completely off limits. What's more, there is no factual record before this court.
Well, suppose somebody decided that the best way to get gold out of a river is to lower a depth charge. Because, that is blow gold right up into the...
I got it. That's what the law professors say. We can have an atomic bomb to dig these things out.
Well, I wouldn't go quite that far, but help me with the depth charge example.
Okay, the depth charge example is that we have a large body of case law on what reasonable environmental regulation is. We have the case of the United States versus Richardson. You're not allowed to use dynamite unless it's really, really necessary. So in that case, they told the miner, you can't use dynamite, you've got to use this core drilling method instead. The courts have developed a body of law over 100 years to narrow and protect environmental values on the federal regulatory
But
side.
to pick up on Justice Corrigan's question, what aspect of the depth charge problem or mining activity in general can the state regulate under your theory?
Under my theory, it can do what Granite Rock told it can do. It can have reasonable environmental regulations that do not interfere with the federal policy. And what is missing so far, and what I really want to try and hammer home today, is the nuances of that federal policy. Because when you march through all the statutes, you'll see that there's a fundamental difference and inconsistency between the federal view and the state view. And I'll just jump to the end before I go back, which is the federal view is the minerals are there. They're in a place, okay? They're not anywhere else. The only way you can get the minerals out is by taking them out of that place. And you can't take them out of that place without causing some environmental impact. It's inevitable. And so the whole structure of federal law, not just the statute we've discussed before, but the Federal Land Policy and Management Act, the Forest Management Acts, all of these statutes talk about unnecessary and undue degradation. This may be analogized to what you have in CEQA. In CEQA, you have a circumstance where an agency in California wants to do something, and there's significant environmental impacts. And the agency can do what's called a statement of overriding concern or something like that, where the thing says, okay, we understand there's significant impacts, but the policy is we want to do this for policy reasons. And that's what Congress has said for minerals. We have a statement of overriding concern because of things like 21A's national security, industrial needs, this need for stable mineral industries, all these things that are destroyed by moratoriums. We have overriding policies here. And what happened instead? The state comes in and says, we've got environmental laws, we've got water quality laws, we've got air quality laws, we've got disposal laws, but these laws and the standards that are in these laws, the reasonable environmental standards, they can't stop the mining. And we don't like the mining. We just want the mining to stop. And we've got to pass a new law that says we're going to prohibit it.
Okay, that's a lot. How do we, as a court, cash out the principle of reasonableness that you want us to apply here?
You look at 612, and you look at the federal statutes that explicitly give authority under the water pollution control standards. Things like water control standards are right there in the federal law. You can do that. And there are standards. But the standards don't bar this activity because this activity is so utterly insignificant that it doesn't violate the standards. That's what's really going on here.
So you take the view that
we have to switch to a prohibitory approach instead of an approach of reasonably addressing the environmental effects of the use. And that's what we say we cannot do.
You're asking us to essentially second-guess the agency's determination here of both the potential harm of suction dredge mining and then the proper way to go about ameliorating those harms.
Well, I got a better argument than that. The better argument than that is that under the obstacle theory, what the state's motives are essentially functionally irrelevant. You said that in this Marc N case, that's in Medtronic. What we look at is the federal objectives and whether they are interfered with. And the federal objective is to have this overriding policy that says sometimes we're going to have some significant effects. And we can't have a state statute that says, oh, you've got to fully mitigate every effect we can think of. And the history of that provision indicates that it's expressly designed as a prohibition.
What about the early, the late 19th century ban on hydraulic mining? That seems even...
He's wrong. He didn't ban hydraulic mining. You want to know what that statute says? The Public Resources Code, section 3923 or whatever, it says, the business may proceed so long as there's no material injury to these lands downstream. Because this was real harm. This is like the whole rivers, it's washing out bridges, it's covering thousands of acres of farmland with rocks. These are effects that are miles away, and it was an attention to environmental effects on a specific case-by-case basis. It was early environmental regulation.
So you're going to argue with your opponent here about whether or not the dislodging of mercury into waterways that go into people's houses is or is not sufficiently harmful?
Of course, because what he didn't tell you is mercury is like gold. It winds up in the dredge and they take it home. And what they're fighting about is there's this 1% little piece that goes back in and falls back where it was, and some of it might drift a little further downstream. Other states, they run these programs, which is the dredgers help collect the mercury. The papers that they have written on this thing are just They are fraudulent.
So, counsel, is there any factual circumstance under which a moratorium on suction dredging would count as a reasonable environmental regulation as you understand it?
I
Any
don't think
fact
so.
pattern, any scenario?
Not where it has been underway for decades without killing or hurting anything, and the federal agencies are essentially expressly authorizing it. Because that's what we got here. We put in the record the Forest Service decision. The guy comes in for his Forest Service approval. Forest Service comes back, where's your California permit? He said, well, that's not reasonable, they won't grant one. Forest Service takes it out. Well, we're regulating, it's fine. To answer your question, maybe if you had this new method of mining, okay, nuclear bomb method, all right, and somehow the federal agencies were all asleep, and somebody said, well, the nuclear bomb method is so wild that, maybe we should study it, and the feds didn't say anything. But that's not what we got here. We had a functional system in place for decades, and nobody ever got hurt. There were no dead fish, there were no sick people, there were no traces of anything anywhere that could be measured. There is nothing. And
Doesn't the regime have to leave space for the state to be able to study whether or not the effects are as minimal as you say, or more on the nuclear bomb scale?
Sure, it can study. It's
So
been studied it for years. It's studied it for years before the moratorium.
So at what point, in your view, does it become impermissible for the state to study those environmental effects? What's the difference between permissible studying?
Nothing ever stops the state from studying. What we say the state is not allowed to do is enact what is in character a prohibition. And that's why we have the 8th Circuit, we have the Federal Circuit, we have the Supreme Court of Idaho.
So the state has to let a particular technique that may or may not have tremendous environmental harm continue while it's studying to determine exactly how severe or not severe those harms are, in your view?
Has to let it continue.
So in other words, the state can't say, we're going to put a halt to this particular activity while we study whether or not it has unreasonable environmental effects.
If you turn over all of preemption law and you put aside the interference with federal obstacles and you start revising preemption law to reflect the strength of the state's motives, I think you need a record to do that. You don't have that record in this case. I mean, we filed a lot of stuff, but it's not a record in the trial court. It's not, a lot of what they say is not properly before the court. We can demonstrate beyond a shadow of a doubt that there is nothing here that should give rise to this concern. If the court got into
okay, so now we're talking about two different questions. One is the extent of preemption law, and the other is whether or not the decision makers here made a reasoned and informed decision. You say they didn't because your studies and the opinions of other people disagree. That's a little different from preemption law. So I think it would be helpful to disaggregate those two arguments. One has to do with whether or not they're right, and I'm discerning that perhaps you think they're not. The other is the degree to which the federal government has intended to preempt this kind of state action.
Let me return to that.
And as you return to it, let me focus the inquiry in this way. The Federal Mining Act goes back to 1872. The views of governments generally and people around the country were a little less refined with regard to environmental protection then than they are now. So I'm wondering how that factors into the equation.
Well, the Act is not in splendid isolation. What about the Endangered Species Act? I mean, if this thing took Endangered Species Act, it would be subject to being shut down under the Endangered Species Act instantly. Okay? There's what about the Water Quality Act? There's 50 different acts to protect environmental values.
That may be true, but we're not examining those.
Right, but why do we need? Why? If we're worried so much about the state and the environmental values, why do we have to authorize the state to flatly prohibit any effective mining whatsoever when it's got all these other laws? I mean, to return to your point now, to answer the question, 1872, the effects that they were thinking of then were these damage to downstream lands and things like that. You can see that in 30 U.S.C. 51, which actually goes back to 1872. Then we come up to 1955, and we have there the no material interference standard. And it's quite clear that federal agencies can't prohibit or can't severely restrict to the way these people did. They can't do it. Then we have the Minerals Policy Act in 1970. Then we have the overarching Federal Land Policy Management Act in 1976, I think it was, by which time we had the Clean Water Act, the Clean Air Act, all the environmental statutes were in place. And again, the focus was on undue and unnecessary environmental impacts. This whole federal approach that gives the overriding policy of we have to have some impact to give the minerals out is what the state is frustrating. It is frustrating that through this device of prohibiting and saying you can never do it until there are no effects at all. And the effects that they're talking about are really wild. It's not about fish. The regulations say there's no harm to fish. Those were the regulations that weren't good enough. And that's where we are. We're underwater with the fish. They come in with things like, well, there might be birds, or let me take another one. Traditional cultural properties. When you're underwater in a river boiling with boulders down every winter and so forth, there's nothing there. There's no, Native American temples or anything out there. So they came up with the idea that the whole river is a traditional cultural property, and for the miners to be present in this traditional cultural property is a significant impact, and that's got to be fully mitigated. Well, how do you do that? No miners. There's no other way. I mean, and the water quality thing. The water board, this legislature has expanded the ban now and said, we're going to give you the power to prohibit it. And what did the water board say? They already are on record saying there's no way to eliminate the impacts except to prohibit the thing entirely. We can't have zero impact without prohibiting it. That's what the state wants. Zero impact. And that is what is, like giving the finger to the federal policy. It is not the respect that is due to a coordinate sovereign. So that's what I'd like to try and leave you with is there is a real powerful conflict of policy here. There is the federal sovereign that says we have got to get minerals out, and there's just going to be some effects. We can have reasonable regulation. We'll trust the agencies to deal with this. But we can't just say, I'm sorry, there have to be no effects whatsoever. And that's what California is saying, and that is an obstacle. It's clearly an obstacle. And it's because it's so clearly an obstacle. It's clearly an obstacle. And it's because it's so clearly an obstacle that we get off on all these sideshows and these arguments about preemption law that are just completely wrong.
So can I ask you for a clarification? Is that what you are relying upon, this conflict, to overcome the presumption that there is no federal preemption absent a clear and manifest expression of it?
Let me say,
I know you've talked a lot about the intent and the minerals in the land, and it has to come out and there has to be impact. And yet, I start from the place where we all start, just, the law school question of preemption is disfavored. And so in order to find federal preemption of a state law, especially implied, that you have to have a clear and manifest expression of the intent. So
that's we disagree on that, and so that's too simple because there's case after case after case that I cite in the brief where there's no mention of preemption at all. It's a more nuanced approach, and Your Honor's adopted that more nuanced approach in December.
So let me ask you, so you disagree with the statement that we examine the claim of implied preemption from the starting assumption that displacement of state regulation, quote, was not intended absent clear and manifest evidence of a contrary congressional intent?
I think there is clear and contrary evidence here because what you
Okay, so what is the clear and contrary evidence that you say indicates federal preemption
because no state
exists?
ever tried to do this. No state ever tried to ban mining. Every time they tried to do it for 100 years, it was struck down as preempted. That's the background that Congress legislated against.
Did you say the banning of mining?
Yeah.
And your position is banning suction mining is the equivalent of banning mining, period?
If it frustrates the objectives. Take the Brubaker case, Supreme Court of Colorado. All they banned was core drilling. Okay? But core drilling is part of what you have to do to develop a mine. Just like suction dredging is what you have to do here. And they looked at it and said, I'm sorry, you can't do that. Or Lawrence County, or case after case. This would be a different case if they walked in here and said, wait a minute, here's 55,000 state law bans that have been in place for 100 years. Your case last said, and I quote, we have to have reason to discount the possibility that the Congress that enacted the legislation was aware of the background tapestry of state law and content to let that law remain as it was. But there was no background tapestry of state law. This is federal land, and nobody ever thought to go in there and start forbidding things on it. Until Granite Rock was decided in 1987, the general view was it's field preempted.
Counsel, could we look at the logic of your position? As I understand your responses to the Chief Justice, you do not disagree that we begin with the general proposition that preemption is disfavored.
There is a whole spectrum in which that goes. The Crosby case says, in some cases, it's so well settled you don't even mention it. In other cases, food and drug safety, where the states have been in there passing labeling laws, most of these cases are labeling laws, where there's 100 years worth of state regulation, then there's a real powerful preemption. But there's a whole spectrum of preemption here. And this thing falls into the class of cases like foreign affairs, or Granite Rock doesn't have any mention of preemption. Search for the word preemption in Granite Rock. You won't find it because this is sort of a classically federal area. So the strength of the preemption is a function of this background tapestry of state roles. And if you're going to give respect to a coordinate sovereign, you have to take account of the degree to which these two sovereigns have been active and what their policies are and what they're to accomplish.
Does it matter at all that the sovereign in question, the federal government, has filed a brief disagreeing with your view of the degree of conflict posed with
I don't think
policy?
that what some attorney in the Natural Resources Division thinks about congressional intent is any more than his opinion. I mean, the whole idea that federal agencies are somehow empowered to make decisions in this context. You have agencies that, as a matter of law, in their own manuals say, we can't prohibit it. And we're supposed to believe that these agencies that can't prohibit it were granted by Congress the power to say, oh yeah, but we were granted the power by Congress to authorize the states to prohibit it. It's preposterous. It really is. I mean,
But didn't you say earlier that the federal government's take on a particular method might be relevant to the analysis? I thought that part of your argument earlier, you correct me if I'm wrong, is the federal government had taken a position with respect to this.
I was just pointing out that the only relevant take we have here, because Mr. Reinhart was on Forest Service land under Forest Service regulations, is the take we put in, which is 228.8, you do it where it's feasible to the extent you can, and then we put in the suction dredge miner who said, okay, give me a plan, and they came back with a plan and said, oh, well, you got to have your California permit. He said, wait a minute, they're not issuing permits, and so the Forest Service struck that from the plan. They were like, as far as the federal government is concerned, you can go ahead whether you have a California permit or not.
Counsel, could I suggest that if you want to reply to Justice Cuellar's question, you let him ask it first.
I'm sorry.
So I simply wanted to understand the extent to which your argument depends on positions that the federal government takes and can change.
I think those are just totally secondary evidence. The primary evidence is that for 100 years, in 1872, in the 1890 Organic Act, all the Forest Service Acts carefully preserved the minerals. 1955, 1970, 1976, we have 100 years of congressional legislation over and over again. That's what matters, not so much what some agency or what some Natural Resource Division lawyer thinks about it. And as I pointed out in the brief responding to that, he's just some kid. I know. We've done cases together. The Solicitor General, who signed the brief in Granite Rock, took exactly the opposite position with respect to exactly the same laws that were all in effect at that time. So
well, presumably, there were some intervening events, including the decision in Granite Rock.
The law didn't change. Congressional intent didn't at all. I mean, the law is what the law is. One lawyer says it means this, another lawyer says it means that. So what? I mean, it's what the law means that matters. And I think the Solicitor General's opinions of what the law was were a whole lot more persuasive than what this guy's opinions were of the law. I mean, there's whole issues we haven't even covered. There's this whole process whereby states work to induce the federal government to shut down mining, to withdraw mineral lands. Why would we have that at all if Congress thought states could just shut down mining? Why have those federal laws at all? It's fatally inconsistent with a state power to ban mining to have two different statutes, I think it's 30 U.S.C. 1281 and 43 U.S.C. 1712, something, that give these roles to states to try and get the Secretary of Interior to withdraw the land from mineral entry. Why have those? It's manifestly intent that Congress never could possibly have imagined that states would be going out and banning mining. It's just not even, it's not even close. What else did he say that wasn't true? Commercial impracticability. There's been a lot of attack on the Court of Appeals opinion on this point, and in particular about the price of gold fluctuating and so forth and so on. One point that's not in the briefs is that the Garcia case that the law professors rely on was in fact overruled by an unpublished Fourth Circuit decision that I found last week, 442 Fed Approx 745, which adopts a special standard in precious metal cases because of fluctuating prices. So again, there is a whole body of federal law on how to ascertain reasonability that is out there. It comes down to a rule. It comes down to a rule of reason, and I submit that it's just not respectful for courts to it's not respect to a coordinate sovereign to just say, well, we're going to ban it. I understand that maybe somehow, some way, people think that they need to study something. The record here reflects that the studies were underway years before the ban. The record here reflects the studies were conducted, a set of regulations was produced, it was no harm to fish, no real harm to anything else, a few more, but you can't have stable mineral industries if the state is allowed to ban it and ban it and ban it and ban it. There comes a point where it becomes unreasonable. And I'm sorry that there's not a more bright line test for unreasonability, but Lawrence County, which the Court of Appeals properly relied on, is dead on point. And it takes what's a very functional approach. It says, look at this thing and see whether it's of a prohibitory character. And that's what a moratorium inherently is, especially a moratorium that sneaks in this substantive provision that we've got to have 100% perfect mitigation, so it's not really a moratorium at all. It's a disguised ban. That's what's going on here. If you look closely at the legislative history, it's all about prohibitory intent. And it's not about just addressing the environmental standards. It's not about, I'm not here because this would be a different case. And Mr. Reinhart was told, well, you can't have a permit because here's a water standard and you violate it. He'd be probably dead in the water if it was a water standard and if he violated it. But it's because the standards approach, the effect-based approach, all of these other statutes, all of the things that are listed in the Federal Service and the Forest Service regulations, it's because these things all were met that they had to come up with these evolving schemes over and over again to just shut these people down no matter what. And that's what this is really about. It's about shut them down no matter what, but let's articulate some environmental concerns and so forth and so on. And I guess what I'd like to say is there's a large body of law, in addition to the law that says the state's purposes aren't really that relevant. There's also law, I think the Perez case, if I remember correctly, which talks about how these assertions of motive they're just not enough. I mean, imagine if the rule were that an environmental effect could justify conflict with federal objectives. So, for example, the state of Arizona recently tried to make things hard for illegal aliens, right? So what if Arizona's position was that, well, we've got too many illegal aliens and it's bad for the environment? I mean, at some level, there's nothing more bad for the environment from a modern perspective than more people. So why can't Arizona clothe in that and say, we can totally frustrate federal objectives because we're doing it for the environment? Or I mean, you can think of a parade of examples, but it's about interference with the federal objectives. And I think once you show interference with the federal objectives, you have made your case. We have carried our burden of proof. Presumptions are funny things. You look in an evidence textbook, you'll see there's different kinds. Some presumptions disappear instantly once evidence is produced. Some presumptions are putting a thumb on the scale. We've never been really clear about what this presumption is, but it's
so before your time runs out, since I just heard you say this all depends on this interferes with federal objectives.
Yeah.
And I have heard you say what those objectives are, but since your case seems to turn on it, would you recite for us succinctly again what the objectives are?
To secure the development of minerals on federal policy, to secure a stable mineral industry, to grant rights to mine that are being frustrated, to establish an overriding policy that, notwithstanding inevitable environmental impacts, we will limit our regulation to that which is reasonable and doesn't, and reasonableness doesn't totally interfere with getting the minerals out.
Okay.
That's all the statutes boil down to that proposition.
Thank you.
Am I?
You have 2 minutes.
Okay. The next thing to go to probably is, I think we've covered nearly everything. Just the case, just the history of all the cases. You know, Congress also legislates against the cases, and nobody's been able to distinguish these cases very much at all. He said Lawrence County didn't ban mining, or banned all the mining. No, it didn't. It banned new or amended surface permits. So all the existing surface mining operations could continue. So it was a partial ban, and it banned these permitted operations, and nobody said you couldn't go pan for gold. I mean, in any other context, it's difficult to imagine the state of California coming in and saying, well, you can use a teaspoon, you can use a gold pan, and that's really what the mining law was about. The mining law wasn't about teaspoons and gold pans. It was about getting out significant quantities of minerals. And our clients are here today because that's what they want to do. They want to vindicate the purposes of the federal statute. And so we have the interference with their rights, we have the interference with the objectives, we have the whole line of preemption law that's sort of like land use. What's this line between what's land use and what's an environmental regulation? You know, water quality standards, that's clear environmental regulation. Saying you can't use the land for this, and he admitted a minute ago, this land is dedicated to mining use. You can't really use it for that.
Mr. Buchal, your time's expired.
Thank you very much.
Thank you. Mr. Buchal, your time's expired.
Thank you very much.
Thank you.
Counsel, a question before you respond to what you've heard.
Certainly.
Does your success in this case depend on this court's concluding that all mining use of the land is not banned? In other words, if we conclude, as your opposing counsel says, that everything is banned, this moratorium is equivalent to a ban, do you lose?
If it banned all mining and there was no way to
Extract the
minerals in California, then I think I probably lose.
Well, I don't know about in California, but in this claim.
I don't think so.
Well, do you think there is? Okay, go ahead.
Because let's say the claim is in a place, let's say the claim is in Yosemite National Park or an equivalent state park or someplace that's really special. That's probably not possible, right? This is federal land. So in some special place, why can't California say, look, we need to protect this resource, this river, these endangered species. You can't mine in this location.
All right, so that's your view. But actually, you don't take the view that this ban deprives Mr. Reinhart of all his interest in the mining claim, do you?
No. He can mine on the land. He can mine with non-motorized methods, and he can wait till the moratorium ends.
But the economic viability is not important.
Correct. Did I answer your question?
You did, thank you very much.
A couple minor things, and then I want to talk about something. First of all, Mr. Buchal started off by saying that 30 U.S.C. 22 had to do with these local minor regulations. But that is not the meaning of the statute, because the statute says, under regulations prescribed by law and according to the local customs or rules of miners in the several mining districts. So those are two separate things. So I think we go back to what we talked about before, which is that under regulations prescribed by law includes state laws. Secondly, there's been some discussion about the United States' amicus brief, and I think the United States Department of Justice does not have briefs filed unless they go through the appropriate channels. And we were told that the Solicitor General's office approved.
And is that in the record anywhere?
No, of course not. No. But they don't file briefs unless they're approved. And I assume this went up as far as it needed to go.
And that's in the record somewhere?
Hmm?
That's in the record somewhere?
Well, they filed the brief.
Well, I assume that
That's
if
in
we,
the record.
Yeah, right.
I assume if we get a brief from the United States Attorney General, we take it at face value and we don't go through hierarchies or personalities or junior attorneys or senior attorneys. It's a brief for our purposes.
Right, exactly. Mr. Buchal likes to talk about all these cases that he says that struck down bans of mining. The cases are universally in recent history, but before Granite Rock, except for South Dakota versus Lawrence County. All the other cases he cites were before Granite Rock. And I think it's important to realize what Granite Rock ruled. So in the Ninth Circuit, the court in Granite Rock, the Ninth Circuit ruled that the county cannot prohibit the use, either temporarily or permanently, in an attempt judgment for that of Congress. And this view, Justice Powell said, the court's opinion today approves a system of twofold authority with respect to environmental matters. The result of this is that state regulators, whose views on environmental and mineral policy may conflict with the views of the Forest Service, have the power, with respect to federal lands, to forbid activity expressly authorized by the Forest Service. I dissent. And the majority addressed this point. And they said, in their conclusion, that they did that principle. Submit that Granite Rock stands for the proposition that can balance these interests differently than the federal government, even on federal land. And that's what the legislature has done. And they haven't done anything unreasonable here. They have asked for a study, and they have said that we want full mitigation of all significant environmental effects. Not all effects, significant environmental effects. And as this court knows, under CEQA, significant environmental effects are judged against a threshold of significance. And the thresholds that were not de minimis. As to fish, the effect had to be on a population level. As to mercury, there had to be a significant adverse effect on a beneficial use. Those thresholds of significance are in the record. We asked the court to take judicial notice on those documents. These are not de minimis effects. I understand that Mr. Buchal disagrees with that assessment. He can have a different position.
Well, he
But
can have a
he's
different
not the one
position,
who
and he
gets-
says they're not significant, and you can have a different position, and you say they are significant. Counsel, I suggest that doesn't advance the ball one iota. All we're hearing is your opinion and his opinion.
No, but
So if you could ground your argument in something more substantive, it might be helpful.
And then you may answer the question, but your time's expired.
It's not my opinion that matters. It's what the agency and the legislature decided. And the legislature decided we want full mitigation. And this agency, after doing an EIR over 2 years, costing $2 million, that is over 1,000 pages, came to these conclusions. Mr. Buchal has challenged those. Those will be litigated. But those judgments are entitled to respect. And if we go down a road of saying that reasonable environmental regulation is all that's allowed, then we start to second guess the agency's decisions. And those agencies were empowered by the legislature.
Thank you, Mr. Melnick.
Thank
Thank you,
you.
counsel. The matter is submitted.